now call 123-637 Kansas, State of Kansas versus Bilbrey. As counselor moving forward and getting settled, I would like to say to all four counsel, express my appreciation for your cooperation and shuffling the docket. And for those that may be tuning in on and surprised that they're hearing these cases, we did have to make changes to the docket last week to accommodate an emergency situation for counsel that had been scheduled to argue today. And we just appreciate your willingness to work and accommodate your colleague in that way and working with the court. So thank you very much. And thank you also, Mr. Shima, for doing all the legwork to make that happen. So, Mr. Shire.
Again, Your Honor, I'm Casper Shire, appearing for Dustin Bilbrey. Dustin Bilbrey made a pre-sentencing motion to withdraw his no contest pleas to aggravated robbery and several other felonies in this case. The district court denied that motion, and this appeal focuses on two of the claims that Dustin presented to the district court to show good cause to withdraw those pleas. First, Dustin was never shown the bulk of the video discovery in this case, and he was on record with the court at least twice saying that he was not comfortable either entering into a plea agreement or moving forward to trial without seeing that critical discovery, which included surveillance footage of the conduct underlying these alleged offenses. The only reason that Dustin's attorney ever gave for not showing him that discovery was that Dustin was in jail. Second, on the morning of Dustin's trial, minutes before it would have started, the state threatened to arrest and prosecute Dustin's brother for months-old drug charges if Dustin did not decide to enter into a plea agreement. The district court committed two errors, reversible errors, in denying Dustin's motion. First, it applied a standard higher than mere lackluster advocacy to find that Dustin was represented by competent counsel. And second, it made a critical factual mistake in finding that Dustin, and not the state, was the one that injected Dustin's brother's legal fate into the 11th hour plea negotiations.
On the video question, don't you have to show court applied the Strickland standard to the first Edgar factor in order?
We have to show that they applied the wrong legal standard.
Which is
yes.
Strickland. I mean, it's got to be, there's no other legal standard. It's either the good cause factor that's in the statute or it's Strickland. There isn't any other standard, right?
There's no other articulated standard that I'm aware of. No, Your Honor.
There's none that you're arguing, I guess is what.
No.
So where do you see that the court applied Strickland? And the reason I ask that is because when you look at the transcript of the court's denial of the motion, it specifically cited to Woodring and that case does not use Strickland, and there's no reference to Strickland in the court's order. So how do you get us to the fact that the court applied Strickland when it didn't cite it, and the law that it did cite in denying the motion specifically does not deal with Strickland? In fact, it cites Aguilar, which says you don't apply Strickland.
I'll point you to three things, Your Honor. First, at the outset of the district court's ruling, it references ineffective assistance of counsel, not lackluster advocacy. And when we're talking about, and that's on page 4 of volume 21 of the record. And when we're talking about ineffective assistance of counsel, obviously we're talking about Strickland and not about the lackluster advocacy standard. 2, later on in the district court's ruling, when it is specifically addressing the claim that Dustin's attorney didn't make the effort to show him this video discovery, the district court says in part that it's denying this motion because it hasn't seen statute or case law requiring Dustin's attorney to do this. That's not the question. The question is not whether or not there is black letter law that says Dustin's attorney had to do this. And by framing the question that way, it certainly looks like they're applying something like the Strickland standard rather than the much more relaxed, lackluster advocacy standard that we see in cases like Herring. And third, I would urge this court just to read the entire ruling in context, because by looking at the hearing, it's clear that the district court is not looking to see whether Dustin's attorney's representation left something to be desired, but rather whether it can point to something in the law that says, yes, because I've got this case or because I've got this statute, this is something that I can find is ineffective.
And when I read the entire ruling, I don't get that. I mean, I see a district court judge that listed maybe a dozen different aspects of how the defense counsel worked really hard to communicate with the client, to make sure that he knew what was in those videos, because the jail doesn't have the capacity to show the video to him. Overcoming that, I mean, the court mentioned that this is a defense counsel that filed a motion to suppress that was successful. All of that is the discussion you would have about a lackluster representation. And we all agree the court doesn't have to use the phrase lackluster or else there, right?
I agree to that, Your Honor, but
Get on the rest of it, because like I say, I read the ruling. I don't see what you're arguing in that. Where am I wrong?
well, Your Honor, I think the problem is, one, at the outset, the district court cites the ineffective assistance of counsel standard without citing the lackluster advocacy standard, which puts this ruling on the wrong track to begin with. But second,
It uses the term ineffective assistance of counsel. It doesn't state the standard, because the standard would be Strickland.
the standard for ineffective assistance of counsel is Strickland, but Your Honor, I don't think that the court needs to use the word Strickland to show that they're using the Strickland standard. I think by saying ineffective assistance of counsel, by demanding that Dustin show statute or case law showing that he's entitled to relief, which is certainly not the lackluster advocacy standard, the court is holding Dustin to a higher standard than it should have. And second, Your Honor, the fact that the district court made thorough findings is one of the things that the Court of Appeals relied on in affirming the district court's ruling. Our position is, if the district court applies the wrong legal standard, it does not matter how thorough those factual findings are. Thorough factual findings cannot save a district court order that is based on the wrong legal standard. So while I don't necessarily disagree that the court made thorough factual findings, I don't think that's the issue. I think the issue is, did the court apply a standard higher than mere lackluster advocacy?
Why you want to go to the case law that the district court cited in its ruling, and that case law is specifically on the good cause factors, not an application of Strickland.
And in fact, the issue there is Aguilar, which is competent counsel, and that's how she ended it. That's how she ended it. She said, I find that counsel was competent.
And that the competent counsel thing goes all the way back to Edgar. So the problem with saying, hey, I find that counsel is competent is because that there are two very different standards for determining whether counsel is competent, depending on whether it's a pre-sentencing motion, lackluster advocacy, or a post-sentencing motion, where you have to show constitutional ineffectiveness. So simply saying that counsel was competent, well, that's skipping to the end. It doesn't show that the district court applied the right standard, lackluster advocacy.
Did she invoke the Constitution?
She at the outset of the hearing referenced the ineffective assistance of counsel standard, and then later on said she was looking for statute or case law saying that that counsel had an affirmative obligation to show Dustin this discovery. And I think that's enough to find that she applied a standard higher than mere lackluster advocacy, Your Honor. I'd like to talk also a little bit with the time I've got left about the error of fact that we're alleging in this case. The district court found that it was Dustin who injected his brother into this plea agreement on the morning that his trial was supposed to begin. And it's our position that there is no factual support for that finding in the record. In fact, to the contrary, the evidence all pointed to the state injecting Dustin's brother into plea agreement.
Why does it matter? Isn't this prosecutorial discretion?
No. It matters because there is a big factual difference. It matters because the question we're trying to answer here is coercion.
Right, but when you talk about coercion, what's the definition of coercion? Backs you in a corner where you have no choice.
Right, sure.
Why does he have no choice? I mean, his brother committed a crime. Then why not just let your brother get prosecuted? Why was he coerced into taking a plea agreement? He made a choice.
He made a choice, but he made that choice and he testified that he made that choice because the state was threatening to prosecute him on charges that were months old and that it hadn't seen fit to pursue before the morning of this hearing.
Right, but he didn't say that his brother was innocent of the crime.
I don't have any idea how he would know whether he was or not.
Well, there's no evidence in the record that.
Can't you also look at it, though, as sweetening the pot? Well, if you accept this plea, I'll also not prosecute your brother.
But whether it's sweetening the pot or not, it's incredibly coercive, particularly when, you know, a moment ago, Your Honor, you asked why it matters that the state asked rather than Dustin asking. It matters because if Dustin is asking, he's not being coerced into making the choice to plead. If it's the state saying, okay, you don't want to take that plea, fine, we're going to go out and arrest your brother and charge him with this drug case that we've been sitting on for about 10 months.
But they've been sitting on it for 10 months. I mean, it's a real case. I mean, I don't see how it's coercion. The guy, Mr. Bilbrey, didn't have to take the plea. Why is it I don't see where it's coercion.
Well, Your Honor, with all due respect, the defendant never has to take a plea. They always have the option to take their case to trial. And I think part of where you're coming from is to say that coercion is inherent in the process. And I agree.
No, I'm not saying that. I'm not saying that at all. I'm saying that, you know, he has a choice whether to take it or not. I mean, this is his brother made the decision to do what he did. And, you know, he's trying to protect his brother. I get that, but that's his decision. You know, I don't see how it's coercive. Coercive is, you know, backing you into a corner where you have no choice. You know what's coercion? I'm going to kill you unless you take this deal. You know, I mean, that's coercion. You have no choice.
Well, I guess I disagree, Your Honor. I mean, even if the choice is that stark, you still have a choice, right? You always have a choice. You cannot.
Or if something's illegal, you know, for example, we're gonna, you know, if we're gonna set your brother up in a drug deal, even though he's innocent, and we're gonna send him into jail.
Yes, and I see I'm out of time, Your Honor, but if I could quickly respond. I think it makes a big difference, again, Your Honor, here that we're talking about a pre-sentencing motion rather than a post-sentencing motion. We're talking about different levels of coercion. Certainly, I agree that, you know, threatening to set a false charge on his brother would have been more coercive than threatening to charge him with a crime that, for all apparent purposes, had lapsed. That doesn't mean that threatening to charge him with a crime that was months old and that the state had taken no action on up to that point was not coercive. And especially when it needs to be judged under a more forgiving, good cause standard and not the higher manifest injustice standard. That is an error of fact that makes a big difference in the way this case comes down, Your Honor.
Quick follow-up, counsel. I think I agree with the gist of what at least I took from what you were saying, which is the plea bargaining process does have some inherent coercion in it, no matter what.
Yes.
The question is it appropriate or inappropriate?
Yes,
coercion,
yes, I
essentially?
agree,
So
Your
my
Honor.
question is, do you have any case law that says that bringing in potential crimes charged against a family member somehow makes this inappropriate coercion?
No, I don't have any case law for
Because-
that.
I'm sorry to interrupt. I don't think you would be here arguing that it's coercion if the crime that the prosecutor forbeared prosecution on was actually the defendant himself. So the only thing that seems to me to set this apart is that it's a family member.
I think one thing that sets it apart is that it's a family member, Your Honor. And the second thing is that, the state, at some point, the state knew about this 10 months before trial, right? The state, at least in the form of,
The state does this all the time in plea bargaining. I don't recall any argument made by a defendant that somehow receiving a benefit of not being prosecuted, even for an older crime, is somehow coercive or inappropriately coercive.
No, I don't think that's inappropriate.
Seems like it's the brother issue. Like, for
It
example,
is.
I can imagine a scenario where, let's say it was a defendant's child. And
Sure.
start that actually, to me, I mean, I'm just sort of entertaining the argument. Whether it's inappropriate or not, I'm not sure, but it does seem to be an even heightened version of coercion if it's your child, let's say.
Well, I agree, Your Honor, and that I think
That prompted my
that
question.
pops into mind the analogy to, the classic case where the prosecutor is in charge of the sync docket and the criminal docket and says, look, you plead on this, or there are going to be sync proceedings.
That was just what prompted my question about any
Right.
case law. I like any cases that talk about
I don't remember the cases by name. I feel like those cases exist. And I think the analogy is certainly there, Your Honor.
Just a factual question. My understanding was that Mr. Bilbrey had talked to law enforcement officers during his interview about not getting his brother charged. And that Mr. Abbey then testified that all the discussions on the morning of the plea hearing really went back to that conversation having been initiated then. Does that change? The fact that it is Mr. Bilbrey that just brought, even if it was disconnected in time in a different conversation, he had early on let his views be known that might be part of his thought process. Does that make a difference?
I don't think it does, Your Honor. It's still an error of fact. First of all, it's still an error of fact that Dustin is the one that brought this up on the day of trial. That's still an error of fact that makes a difference in this case. And second, as the court alluded to, the timeline matters here. The discussion that you're talking about with law enforcement took place in May of 2019. And law enforcement, as they should have, made the standard disclaimers. Look, we can't make promises. We can't make plea agreements. We can't, bind the prosecutor to do what you're asking us to do or to not do what you're asking us to do. And that was, Dustin gave a statement, and that was where things were left. Law enforcement, I think, agreed to put in a good word for his brother, I think is the way they phrased it. And then we have nothing. We have nothing regarding brother's case until January of 2020, when the state is reviewing the video of Dustin's conversation with law enforcement and finds out that this case is out there. Then about a week before trial, the prosecutor asks somebody in law enforcement to prepare a charging affidavit. And that's sitting out there and waiting for, it's sitting there, right, waiting for I'm not sure what on the morning of trial. And I think all of those facts make a big difference in this case.
What's the factual error that you mentioned twice now? about whether the defendant requested that his brother not be charged in the meeting between Abby and Sheehan? And
Yes, yes, and that's on volume 21, page 12 of the record.
and I've got that. So that's not supported by competent evidence, that finding?
I don't believe it is, Your Honor.
I mean, what we would have to do is go back and look at the testimony of the three individuals, right?
Yes, Your Honor.
Okay, and have you done that in your brief to show us why that's wrong? I'm just having trouble tagging that as error. Because I have it in front of me and I just don't know what's wrong with it.
I don't know what to do beyond telling the court that I read the hearing. I did not see the evidence that Dustin asked for his brother not to be charged on the morning of trial. The evidence was that the prosecutor offered that he didn't remember having a statement about Dustin's brother with defense counsel until the morning of trial. And these cases have been, there's been radio silence on this case
But
since,
that doesn't preclude Dustin bringing it up.
but there was no evidence that he did, Your Honor. There was no witness that testified. Dustin was the one that brought this up.
But was there evidence that he didn't?
The,
I mean, there were conversations that weren't on the record. So how can we be assured that it in fact was the state that first brought it up the morning of the trial?
well, the prosecutor himself testified that he didn't remember having any, that he didn't have any of these conversations with defense counsel before the morning of trial.
That
Oh.
doesn't tell me though that the state started the conversation. It tells me they had a conversation.
Well, the factual finding that the state injected this into plea agreements, or excuse me, that Dustin injected this into plea agreements is not based on anything in the record. If anything, the evidence says the opposite. But there certainly is no evidence that Dustin is the one that brought this up. Dustin asked for this on the morning of trial. And that's the problem, Your Honor.
But the way that I read the record, and please correct me if you think that this is an incorrect reading, but the morning of trial, it seemed like the prosecutor was not interested in any plea agreement at this point. And the defendant, Mr. Bilbrey, told his lawyer he wanted less than 111 months. And his lawyer said, he's not going below 111. And Mr. Bilbrey said, I want to hear that out of his mouth. And then the prosecutor said, I normally don't meet with the defendants, one-on-one, but he went ahead and did that in this case, and even though it was eating into when trial was going to start. So they did meet together. And then the prosecutor said, I'm not sure who raised what at what time, but it was the defendant that initiated this plea negotiation in the morning. Is that right? That disputed?
No, I don't think any of that is disputed.
Okay. I mean, I know it doesn't go to your point, which is who injected this, specific item into the record, which I don't think that there's any evidence at all on who brought up that specific subject, right?
That's right. And that's the big problem we have with this ruling is that the court is saying it was Dustin that asked for this. And it wasn't. And that makes a big, there was no evidence to support that. And that makes a big difference in this case.
Is the court, the state appears by Assistant Solicitor General Natalie Chalmers. Or just really quickly before I move to my argument, there is what appears to be a factual error in the Court of Appeals' opinion on page 5. And it goes to pretty much what you were just saying, Justice Dandridge. It is not in dispute that the defendant himself is the one that initiated this conversation the morning of. But on page 5, it says, but Abby testified he initiated the plea negotiations. While that he is ambiguous in context, it reads like they think Abby investigated that, but there's no record support for that. And that would not be factually accurate if that is what they're trying to say. And record 2024 5 is my record citation for the fact that Abby did not testify. He testified that the defense attorney came to him and asked him to come talk to his client. As to the things I agree with the Court of Appeals on, that there was no good cause here, I guess I'll go in the order that Bilbrey did, which I think my biggest issue on the failure to view these videos, one, I agree with Justice Biles that nothing here shows that the district court used the wrong standard. The court cited the right case law, and no one even argued the lackluster standard. So I don't think district court should be faulted for not using that magical word. But also, we still don't know why these videos matter. And I'm hard pressed to say defense attorneys' conduct is lackluster or anything like that, when there's no evidence that these videos, if the defendant had in fact seen them, would have been the reason that he went to trial. He pled knowing that he hadn't seen those videos, and there has been absolutely no evidence as to why the ability to view these videos means he would not have accepted the substantial reduction in the potential penalty.
Doesn't a defendant have a right to review all the evidence that is contained in his counsel's file? I guess I don't understand what the problem is here in him viewing the videos. What's the problem? And I don't think it's anything outside of the realm of what should be expected of counsel to review with his client all the evidence, or particularly the evidence he wants to see.
Right. I don't know if it was a timing issue. The only testimony I have is defense counsel saying that the jail didn't have the equipment. I don't know why defense counsel can't bring in a laptop and show videos.
I didn't understand what the problem was in disclosing to his client what he requested to view.
I know the defense counsel said it was in the police reports. I told him what was in the videos. That's all I thought I had to do. That's the only thing.
So just piggybacking on what Justice Rosen said, whether it's an error of law, the issue that was briefed before us and that is presented to us for decision is whether there was an error of law in the district court's decision, whether the standard was too high. But really, what I read the entire record, and when you look at that, he raised this twice before the district court and said, I don't want to plea until I see all the evidence that has been garnered against me. And when you think about, whether it's a dash cam or whether it was a camera that was showing him, I mean, why shouldn't he be shown that? Why couldn't his lawyer have brought in a computer and shown him in the prison? I just don't understand. There could be things, why isn't that almost even a constitutional right to be able to see that? Because in order to build a defense, that there are things on there that he could point out. Well, I know that guy, there's a witness right there. That could be a witness for me. It is beyond me how that request was denied and brought, I just am blessed. I do not get that.
And without knowing the jail's policy, I don't know, because to me, it does make sense that if a defendant constantly was asking to show videos, if you have time, you bring in a laptop and you show them the videos. I'm not going to argue otherwise.
Well, isn't it true that the jail may have a policy against laptops as potential weapons?
And yes, and that's what I don't know.
But isn't it also true that the judge could bring everyone over and they could use the court equipment to look at it in the courtroom? I mean, there's probably a solution, correct?
I have seen in other counties where if there's an issue like that, they make a conference room available, and it depends on police officers, deputies being available to be able to guard the defendant and the resources and things like that. But yes, I've absolutely seen that happen. So I am not going to say that it is the best practice for defense counsel not to show defendant an evidence that the defendant wants, which is why I'm saying I think it fails the good cause standard, because he hasn't explained why seeing these videos would have caused him to change his mind. He didn't say, well, now having viewed these videos.
How can he say that if he hasn't seen the videos?
He could have seen the videos before the motion to withdraw the plea. hearing and then.
He asked for it twice in front of the judge.
No, I mean, after the plea, he could have seen the videos and presented them as evidence and now saying,
How?
having seen this,
When he was denied twice.
he had
before
new
the plea.
counsel at that point.
Do you think that there was that? So you're saying that counsel was incompetent and couldn't get, but new counsel could have had him view it, but old counsel couldn't? You're making the case for the other
I
side.
didn't say that old counsel couldn't. I don't know. There was no reason given. He just said Ottawa County Jail didn't allow him to do the videos. I don't know what the policy is here. But am I potentially injecting a 1507 of the plea withdrawal counsel? Yes, I am, because it is his burden to prove good cause. And how can he meet that burden when we don't even know why these videos, like, let's say the videos do exactly what the state says the videos do, which is prove the case beyond a reasonable doubt. So he wants to watch those videos, go to trial, get convicted, get an upward departure potentially.
Well, isn't it just as plausible that he was satisfied, that he understood what was in the videos, and that's why?
It is just as plausible as that, especially when the day he had his plea hearing, he said he was satisfied with counsel. He said he wasn't coerced, and now he's coming back and trying to change all of that in a motion to withdraw a plea. So I think the district court here made adequate findings. There's no there's no legal error. And I also disagree on the other issue that there's a factual error. One, I don't know that the district court cared who initiated the conversation about if it was the defendant or the state that brought up the brother being charged. I didn't read that as a crucial finding by the district court, but I do think that if you read this record, there is nothing that refutes that. Substantial competent evidence. Abby said he didn't remember, but it was the defendant himself that brought it up in this motion to suppress hearing, or not motion to suppress hearing, in this interview. It said, I don't want my brother to be charged. I'll basically plea essentially if my brother isn't charged. So I do think there's substantial competent evidence that supports the district court's decision. And I don't think there was any abuse of discretion in this case, and the district court should be affirmed. And Justice Rosen, do you have a question? You look like
Yeah,
you might.
well,
Yeah.
and I don't know if you might be along the same line, because it gets to this coercion aspect. How far can the state go? Let's just take it out of, who initiated, who didn't. Can the state say to Mr. Bilbrey, if you don't take this plea, we're going to prosecute your brother. But if you don't, if you do take the plea, we're not. Is the fate of his brother a part of the consideration that can be given in taking a plea? And I'm just curious of what your position is on that. How far can the state go? And
I do think it depends. I mean, a lot of defendants have co-defendants, and those are regularly part of the plea bargaining process. I think the brother aspects makes it more interesting, and I would agree that bringing children in is even worse. But
even worse. So you categorize it as kind of it's close here. We would say it's even worse.
I just know that most parents would be, well, not all actually, but some parents would be more apt to protect their children than others. And that would be probably closer to the line of coercion. The brother, had the state brought it out of the blue with the brother never being mentioned, I think we would have a problem. But the fact here is that the defendant himself said, I will plea if my brother is not charged. I will take responsibility. That is what he said during this interview. That I think then kind of makes it something that the prosecutor can again mention and say, oh, you made that request. Well, we have no reason to honor it because you're not carrying through with your end of the deal.
I don't know if that's what you were getting.
Yeah, I mean, that's similar. I guess I will follow up with the hypothetical that was in my mind, which is, a hypothetical defendant has been arrested and charged with some serious crimes, and the prosecutor says, hey, we picked your kid up, your teenage son up for shoplifting 10 months ago. And, if you don't plea, we're going to charge him. That appropriate?
I feel like the lesser crime, the less coercive it is. I mean, shoplifting for a teenager is not the same as murder for a teenager, like more serious the crime on this scale of coercion, I think it's going to be a case by case coercion, and is going to depend on the parent. It's going to depend on whether or not the parent then says, this is the reason I did that, or if that was just like, oh, cool, I was going to plea anyway. And that's just sweetens the pot, I think, as someone said today. So I do think it's going to be case by case. I'm not going to stand here and say there's a hard line, but I do think it is probably better practice for prosecutors not to drag family members into plea agreements without the defendant bringing it up.
What test would we use to determine where coercion crosses over from okay to not okay?
I don't, whatever the case law says is.
That's what I'm asking. What is the test?
I don't have a test or case directly on point, but I don't think coercion is not just, and it benefited me. I mean, it can't just be.
Right.
Because then plea bargaining can't happen
Right.
anymore.
I would,
So-
if all we mean by coercion is that the defendant accepts a plea in lieu of something worse.
Right, then every single plea would be coercive and it can't be that.
And
So
or we can just say that's an element of coercion that is part and parcel of the process. There's nothing inappropriate about it. But if we concede conceptually, at least, that there's some forms of coercion that are out of bounds, we've got to have some test, some standard against which to make those decisions.
I agree that a standard would be great. To me, it's as wish-washy as the lackluster advocacy standard is, because I don't know the line on that. Strickland is much easier to apply for me than whatever lackluster advocacy may or may not be. So
Is your answer just that you don't
I don't
know of
know.
a standard?
I don't have a standard off the top of my head. If I could magically come up with one, I would love to do so, but I can't articulate the standard right now. Thank you for your time.
Mr. Shire, before you get started, I just have one question.
Please, Your
Um,
Honor.
You know, I pulled up that State v. Edgar, that this test came from, which, you know, the first one is competence. And this was a pre-sentence motion to withdraw that didn't discuss Strickland at all.
Okay,
I thought you were relying on that to say that it was a Strickland case, Edgar.
well, look, I'm sure you're right about that.
Well,
I-
given the Edgar cases, you know, it might have been that there was also a post-sentence one also. I don't know.
If I'm understanding your question right, Your Honor, I think my answer is that the bottom line is a finding that counsel was competent is not the same as showing, well, then the district court applied the right standard to get there. Because whether or not it's pre-sentencing or post-sentencing, it's the difference between Strickland and lackluster advocacy. So just saying, well, we ended up by saying that by concluding that counsel was competent, well, that doesn't show that the court used the right standard to get there. I think that's my argument there, Your Honor. And I had two other thoughts just briefly. First, this court fielded questions about prejudice. The prejudice in this case is that Dustin was forced to choose between going to trial and seeing these videos for the first time there, or accepting a lengthy prison sentence and never seeing the videos. That's not a choice that anybody should ever be forced to make in our system. Second, this court has been talking about degrees of coercion, and I think that's a very appropriate discussion to be having in cases like this. And, you know, my counsel was up here struggling to articulate exactly what that test should look like. And I would too, if I was put with the same question. It's going to be a fact-intensive inquiry. And
Do you have a proposal for us? Or do you find anything in case law?
I don't have any case law to point to, Your Honor, but because it's so fact-intensive, I'm not sure there's a better way to handle it than providing a non-exclusive list
It's just
of things that look like improper coercion.
you know it when you see it. It's the Justice Potter test.
Well, I don't know if it needs to be quite that wishy-washy, Your Honor, but, you know, we have the Edgar test already, right? What is good cause to withdraw a plea? Well, you look at these three factors, but if there are other things in there, you know, you can consider those as well. You consider the whole picture, but you have to pay attention to A, B, and C. So certainly, I think threats to family members could be part of a non-exclusive list that a court should be paying attention to when they're trying to make that determination, and should be. And that's particularly true when we're dealing with a pre-sentencing motion, good cause, rather than the higher manifest injustice standard. And I see that I'm out of time. Could I sum up briefly, Your Honor? The bottom line in this case is that Dustin did show good cause to withdraw his pleas. The district court committed legal and factual errors in concluding that he did not meet the good cause standard, and we are asking this court to reverse and to remand to reconsider that motion. We thank you for your time, Your Honors.
Thank you to counsel for your arguments in this matter. We will take this under advisement.